Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, how are retirement assets treated in a Connecticut divorce?
So in many divorces, both here and in Connecticut, the parties may have a house, they may have bank accounts, cars, other physical assets, but retirement assets are often an interesting type of asset for a court to consider and for the parties to divide because of the way retirement assets are earned, because of the manner in which they're held, and also how they're paid out over time. A common question is whether a spouse can receive a share of retirement assets in a divorce. And in Connecticut is an equitable division state, which means that everything can be considered and often is considered by a court in deciding how to divide up the assets. So that means both premarital assets and assets that were accumulated during the marriage, even retirement assets. So several factors are considered and brought into the court's division of retirement assets, just like any other asset. And those would be the length of the marriage, the age of the parties, the health of the parties, the earning potential and educations and skill set of the parties. And in some instances, for example, one spouse may have a much larger share of retirement assets already in his or her own name, but that spouse may often have a much higher ability to earn in the future and prepare for one's own retirement as compared to the other spouse. So the court will often look to how close the parties are to retirement and when those assets would be able to be used by a party receiving those without penalty. The court may often award some percentage of retirement assets to either spouse in a Connecticut divorce, or may decide to divide them equally, depending on the position of the parties and their employment situation at that time. Or in the case where there's an inequity in retirement plans, the court has the authority to divide only one plan, for example, in order to equalize both or all the retirement plans. In other words, minimize the number of plans that are split or retirement assets that are split in order to equalize them all. This division of retirement assets can only happen one time, either at or pursuant to the date of judgment. It is a single tax-free transfer between spouses pursuant to a judgment of divorce. And sometimes there's an asset, for example, a retirement asset that might be received either after a trial or by agreement by one of the parties in exchange for something else. So a party could receive a larger share of retirement assets in lieu of, for example, an alimony claim or a distribution from net proceeds of a former marital home, something like that. So one thing that you'll hear in Connecticut divorces and elsewhere is the term apples to apples. And when dividing a marital estate, ordinary retirement plans are not treated in the same manner as liquid assets or real estate because of the different tax treatment. So that means that whether it's $100,000 or $1 million of retirement assets, that would not be equal to 100,000 or $1 million of real estate. Because obviously when retirement assets are dipped into and used by a party, there's a certain tax treatment for those. So how is a division of retirement assets done? In some cases, certain plans will need what is called a qualified domestic relations order. And that's a certain type of court order that's prepared and drafted and signed, and it details how, when, and in which way each spouse would collect their share of a retirement asset after the divorce. This quadro, the qualified domestic relations order, is usually prepared after the judgment is finalized and usually at a shared cost, and that provision is covered in the divorce decree. The quadro is given to a plan administrator that holds the retirement asset, and that plan administrator will very specifically follow the language of the quadro to divide those assets in accordance with the judgment of divorce. If you have concerns about retirement asset division, whatever that type of retirement asset may be, you certainly would be best served to speak confidentially with a very experienced Connecticut family law attorney. Thank you.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hgmurphy@mylaw.com, and please visit mylaw.com for more information.